Good day, everyone. This is Andy Hilger, and I coordinate the North Central Texas Caregiver Teleconnection through the Dallas Area Agency on Aging and the North Central Texas Area Agency on Aging. Our topic for today is legal planning and documents. What do I need and when do I need them? Legal issues are always front and center for planning long term, but sometimes in all their caregiving, people forget how important they are, that they get them done in a real timely manner. As soon as, if they're not already done, make it a priority to get them done. Our speaker today is someone who is highly admired in Dallas County. I worked with her many times, and Rosemary Redmond has been a practicing attorney for over 50 years. She specializes in elder law. Rosemary has also been an ordained minister since 2014. She has worked as the contracting attorney for the Dallas Area Agency on Aging for 3 decades. She particularly loves working with those in need and those in moderate means. In addition to her degree as an attorney, she holds a Master of Divinity degree with a concentration in Black Studies. She is a pastor of Rocket, Texas Christian Church. Although never having taken her vows as a Catholic nun, Rosemary describes herself as a Roman Catholic on loan to the Christian Church. So what a great way to put it, Rosemary. Thank you so much. Welcome.
Thank you, and I'm on. I take it. Well, I'm so happy to have all of you here. We got used to this sort of during COVID, but it's a wonderful way to get together so that during the noon hour, can maybe while you're having your sandwich, we can also get some information. And years ago, I decided to gather up the questions and answers that people had asked, and that I had answers I had provided, and really write it out. And this little presentation has kind of made the rounds. And so I was happy when Xanda asked me to be with you and to give us about an hour to be together. So it is about just in case, not always just in case, because some things do happen. For instance, it's kind of difficult to start by reminding all of us of this, but all of us will at some point pass away. But prior to doing that, and if we have mental capacity, we can make a will, and we can leave behind directions on how our property should be distributed. So it is just in case, but it's also it will happen. And so these are things that people don't like to think about. It's been my experience that men really don't like to think about them. Some men in my office will say things like, "Well, I don't want to do this because I'm afraid I'm going to die," and I have to remind them, no one's ever died in my office. But it's about getting it done, and if we can add a little humor to it, perhaps that's a good thing. So, here we are, just in case, planning for mental or physical disability, and I guess I would add also for documents that would take effect at death. So it's about 20 questions and answers. And Xanda, if you'll give me the next slide.
Well, we just had them, didn't we? Here we
Yeah.
go. There we go.
There we go. And not everyone can execute these documents. And the documents I'm talking about would be a will and the medical powers of attorney, someone to make medical decisions or be there while you're having a procedure. Also, the business or statutory durable power of attorney, and a document that your funeral home can have. So there's a number of documents we're going to be talking about, but the ability of anyone to execute these from will to the other documents depends on their ability to understand the documents. So we look at what is an incapacitated person. Well, we look at a few things. A person who is incapacitated probably has some difficulty perhaps with feeding or clothing or sheltering themselves or caring for their financial health. Maybe they're financial affairs are in disarray. So we look at those as kind of indicators, not always, but sometimes whether that person has the mental capacity to execute a document. And that's what we have to have. And we're going to explore that further. Xander, you want to give me the next one?
Sorry about
Okay.
that.
Uh, we are all presumed to have legal capacity when we turn 18. We're all kind of familiar with that because sometimes our 18-year-old children, we go, I don't know if this is, but at 18, we all are presumed to have mental, and we certainly have legal capacity. So regardless of our actual ability to manage our personal and business affairs. So and this is important. If a doctor informs you that a loved one is incapacitated, I always have to tell people this is not a legal determination. There may still be some room in which that person could execute a document. So we're going to spend some time looking at what does it mean for me to have the capacity to execute a document, and we'll look at that. So in Texas, a person needs a guardian of person in a state only if the guardianship court says that person is substantially unable to perform tasks for their health and finances, and that can lead to a rather expensive guardianship in the court, which actually takes away all or most of the person's ability to handle to make legal determinations, sign documents in favor of someone who is usually in the family that's appointed as a legal guardian. So this determination is made through a legal process where a court through a physician assesses the individual's capacity to manage their affairs. And this is the strongest possible undertaking for an individual because it is a court process. So we're trying to avoid that. We're trying to avoid it by getting these documents done before anything happens to incapacitate us where we can't do it. So Xanda, give me the next one. So when we're 18, we have legal capacity. So how can that be legally overturned? Well, only by a court order. And that's why it's important to look at uh, any diagnosis by a doctor does not overturn the presumption of capacity. So obviously, and I'm sure you're thinking of this already, planning, excuse me, for legal documents, we want to do that before incapacity occurs. And that's certainly preferable to the expense of a legal guardianship. And people ask me, well, when is that going to happen? Well, I don't know. No one knows. And so that's why we're really having this today, is to put in your mind that if you haven't thought about the different documents that we're talking about, that this is a good time to think about them and maybe make some plan ahead. Okay, Xanda, the next one. Number 4. Yeah. When is it too late? Oh, goodness. I used to say this was the $64,000 question, but I guess it's really a $64 question. But it's a critical question. So we just don't know how much time we have to plan, and conditions like dementia, particularly there can be an early stage where the person still has the ability to legally execute documents, and that's still not impossible. So if we have a relative, the usual one I have is a husband, perhaps with a wife with some dementia. Well, how far along is it? Has the doctor said she can't execute legal documents? Well, no. Okay, let's see if we can get, and can that person still sign a document? So there are a lot of conditions and things that we want to ask and put in front of a family while they're planning, particularly if they have someone that is still in the early stages of dementia, where a document can still be executed. Of course, ideally, it's come in and tell the lawyer what you want done and let the lawyer design it. It's not complicated. We just need to know, what do you want, and we design it for you. And so it's just having to face that this document will take place after one's death. But yet the urge and the desire to plan for our families mostly overrides our fear of that. So I'm trying to get the information out that can help you be in a position to plan. Okay, Xanda, number 5. Okay, what factors, and this may be a question you really have in your mind right now, what factors must be present um, for a competent and willing person to execute a legal document? Okay, generally for a person to execute a legal document, the following must be present in the presence of the document. And this is really important, especially with a will. Sometimes wills are challenged. I don't think I've ever had one success. I know I haven't had one successfully uh, challenged because we have the document, the person that's reading it again and signing it. We have witnesses and a notary. And then in the presence of that undertaking, we require the following. The person must be able to sufficiently read the document or have it read to them. We sometimes, with other languages, we use a translator, and that person becomes part of the will also. And they must understand that it is a will. I had a fellow one time that uh, he took his shoes off and his socks off in my office, and he thought I was his podiatrist. And so somehow we never could get to the idea that we were doing a will. And I said, he can't sign this document because he thinks I'm his podiatrist. So they say, well, we should have gotten him in here earlier. Well, I guess that was true. They really have to understand the nature of the document, what they're doing. They must be willing to sign it, and they must agree to any agents appointed in the document, because the whole point of most of these documents, and the will as well, is that you're appointing an agent, someone you trust, in a will, to be the independent executor, and usually an alternate, because these are the people that are going to stand in place of you to get either your will or these documents that do take effect during your lifetime done. And so everybody must physically sign and execute the document in the presence of the witnesses and a notary. I had a will at one point that I went over the woman's house with my 2 witnesses, and I notarized the will. And the next morning, she apparently passed away during the night, and her sister challenged the will. But the will had everything we've talked about. It was a opportunity where the witnesses were there. They watched her sign it. She agreed to sign it. It was notarized, and the judge admitted the will to probate, because everything that needed to be done that's on this page, is number 5, was actually completed. So it's really important, and lawyers know this, and they'll be sure that that's done properly. Okay, Xanda, how about number 6? Now we're going to we're going to come back to wills because they're so important. But a lot of people, one of the questions I'm always asked is people have heard about something called a durable power of attorney. And a power of attorney, this is a document that that is signed during our lifetime to allow someone to share with us the power to either to assist us in handling our health care or our business dealings. So the durable power of attorney, which is actually called a statutory durable power of attorney because there's a lot of law dealing with it, but it's a legal document which authorizes another person to act as your agent. Now, this document remains in effect even if you later become incapacitated, provided that it was executed while you had mental capacity. And this would allow someone your agent, to assist in managing your business affairs. And many of us are very tentative about doing this, but a scenario might be that I have a stroke and I'm not able to manage my affairs. I'm not able to handle my banking or this sort of thing. This document, the statutory durable power of attorney, and I always say for business because this is the business power of attorney, and it does remain in effect even if I later become incapacitated. It becomes effective immediately. And people say, well, I don't want it to become effective immediately. I want it to become effective if I become disabled. Well, if it becomes effective when you're disabled, Now, here's our test question. When am I disabled? Well, I'm disabled when a court appoints a legal guardian. And at that point, the power of attorney probably is, not always, but probably is relinquished by the court. So we have to say in our durable power of attorney that becomes effective immediately. So we want to be sure the person that we appoint as our agent, and it doesn't take away our rights to manage if we can. The person that is appointed as our agent is appointed and can act immediately. And a lot of people are frightened by that. And I said, well, one thing you can do is this is a powerful document, but keep it. Don't give it to that person. Have someone independent that can provide it for your agent if it's needed. So there are a lot of ways of protecting us because we're all a little suspicious. We just are. Okay, Xanda, how about the next one? Number 8, I think. This is probably the most asked question that I have when we're talking about powers of attorney. What happens to a power of attorney when I die? Well, powers of attorney generally expire at death. And if a document has been used to access bank accounts, and this happens pretty often, mom is not doing well, she can't get down to the bank. I need a business power of attorney so that I can go to the bank and get on her bank account so I can pay her bills. Mom thinks this is okay, but physically she can't get around, but she signs it. And then the daughter, for instance, goes down with the power of attorney, gets on the bank account. Okay. Now, these bank accounts, though, if you get on a bank account for someone else using a power of attorney, remember what happens when the person dies. A power of attorney is no longer valid. So if the bank then receives notice and proper documentation that I have passed away, then that power of attorney and access to the bank account will not, the access for the bank account will be stopped. So if a bank account is designated pay on death to a specific beneficiary, a death certificate will usually release those funds, but it does take a death certificate. It takes a while to get that. And also, the power of attorney, if I've gotten on mom's account with a power of attorney, then that's going to expire. It's really much better to earlier do this, take mom down to the bank account. I did this with my mom long ago. Mom and I went down to the bank account and I became a signature on her bank account so that even at her death, I could continue. So there's a difference in the power of attorney expiring at death and being on the bank account with a signature card, which lets me remain on the account after mom passes away. And I always tell people, be sure you get them to print you out the signature card because I've seen those disappear. Who knows what happens in our banking institutions, but be sure you get copies of everything that you sign somewhere. Okay, Xanda, how about number 8? Gosh, do I have any rights left if I sign a power of attorney for business purposes? Well, signing a power of attorney, whether it's the medical one or whether it's the one for business purposes, your rights, it doesn't take away any of your rights. You still retain every right you had. You just share them with the person that is your agent that is listed on the power of attorney. Now, it might be that later on I get where I can't handle my business, and someone that I appointed earlier can assist me then because they have this document. I could get to the point where I can't sign it. And therefore, and this is how we end up with guardianship. Sometimes there's really business to take care of, and nobody has the authority to take care of it if I get really, really incapacitated. Strokes and falling and that sort of thing can really kind of put us out of business. So, but I don't lose any rights. I might not be able to exercise those rights after signing a power of attorney for medical or business purposes. Uh, I have all of them, but the point is, and why we're sometimes rushing to get these things done is, I will not be able to execute them myself if I'm really incapacitated. So, but that's a question that really is asked so often. So that's number 8. Xanda, can you give me number 9? Um, when we look at medical powers of attorney, let me say that there are 3 of them. There's the medical power of attorney, which is just a general document that lets me appoint an agent. And whenever I go in for a test, I remember going in for cataract surgery, and I had my agent with me, and they gave the Baylor system all of this information, all of my documents. They want somebody there in case they come out and they need to ask you. This is not an end of life document. It's just a regular medical permission that I have an agent there in the waiting room in case someone, the doctor or someone, has a question, or we need to make a decision. It's not end of life. So today's healthcare environment is somewhat complex, and I would think that medical facilities, like many other businesses, are all afraid of being sued. So they want to be sure that your agent is there, and that can certainly that can be your spouse as well. And your spouse also needs a medical power of attorney. Been asked this question a lot. Well, this is my husband. Everybody knows the he can make the decisions for me while I'm having cataract surgery. Well, the law says we're not so sure you would appoint your spouse. I had a friend whose husband went into St. Luke's Hospital in Houston for a heart transplant, and she went down and said, "I need to access the suite of rooms for the wife." And they said, "Well, ma'am, there's somebody else in there." And she said, What is this?" And he had appointed his mistress as his agent. So we don't necessarily. It's not necessarily always true that a spouse is appointed. So the hospitals, knowing about that case at St. Luke, are a little bit leery. So if there's a husband and wife, each of them need to do these documents. Kind of a long way of saying that. And usually you would appoint a spouse, generally, unless there's some problem. Appoint your spouse. Each of you would do the 3 documents, and appointing your spouse and an alternate person, just in case that person could not serve. Always we try to appoint an alternate just to be sure everything is covered. So the power of attorney is so important for each spouse or for individuals because it really clearly designates who you've chosen to make decisions. We'll cover the other documents in just a minute, but the main one really is the medical power of attorney. That's the one that's used the most often, and you're gonna be asked, do you have a medical power of attorney, as soon as you step up to the desk to check in for whatever procedure you're having. And you're going to be able to say, yes, I do, and here it is. You can scan it and give it back to me. Okay, Xanda. Okay, what happens if I don't have these? Because most people don't seem to have them. What happens if I don't have these medical documents and I go in for an emergency? Well, you don't have to worry because you'll be treated certainly in an emergency, and even without a medical power of attorney, unless there's someone to object, your spouse or nearby relative can generally make decisions for you. I had a case recently where one of my former clients was in a rehab facility because she had fallen and she had been very injured. And her daughter that was in the Dallas area. Her daughter in New York wanted to come down and get her, take her back to New York. Well, my client didn't want to do that. And it turned out she didn't have the medical documents. So I prepared them, and the person whom she wanted to be her agent uh, got them at the other end, and she signed them in front of the notary at the hospital. And these documents includes the medical power of attorney, but includes something else called we call it the HIPAA. It's really about health information, who can get and give information. Just a little short document. I used to think they weren't very important, but in this case, the hospital, because they were furnished with these new documents and they were scanned in, the hospital wouldn't, she was not listed, the daughter was not listed to get any information. And because the mama was so afraid she was going to take her to New York, and she knew she'd never get back to her home in Texas. And so, as it turned out, the hospital wouldn't give the daughter any information because she was not listed on the health information form. So now I know how important all 3 of these are. The medical power of attorney that talks about who is present there to make decisions during a procedure. The HIPAA form, it says who can get and give information. And then we're going to talk later about one that is really important, and that's the directive to physician, which is end of life decision making. But those are the three documents, and they're each very important. All right. Let's see, Zenda. Ah, thank you. See, you were right ahead of me there. Um, okay, what if I am a widower, and I have several children? Well, I think that's a great question because the medical power of attorney can help ensure a smoother medical treatment if I become unable to make decisions for myself. Um, I had a friend who was one of 10 children, and when mama went into the hospital, everybody showed up, and immediately the medical community was very, very nervous because who's in charge here? And she did not have a medical power of attorney. And the older children and there were 10 of them, I think. The older five and the younger five each had a different idea about what should be done, and mother couldn't make a good decision. And finally, they prayed, and they were able to leave mom on life support because that was the issue. Just leave the older ones wanted to take her off, the younger ones didn't. And this was it was a mess because it took a long time to really come to those decisions. But what that particular mother could have done is appoint one person to make the decision. And maybe she couldn't have come to an idea of who that might be. But this can be a mess for the in the hospital if we don't. This is why we do these documents, to be sure that one person is able to make decisions for me on as to medical power of attorney, HIPAA, and the directive to physicians. Um, what if I can't come up with one person? I'm going to make my children all mad about this. It's far worse to have them all arguing than it is to come up with one person, because by designating one person to make these decisions, you really increase the likelihood the person you trust and you feel is, one lady told me, she said, I can't appoint my daughter because just the thought of this, she would just stand there and weep, and no one would know any information. So this way, you make the decision about who can make in this case medical decisions. Hey, Zenda, number 12. Ah, here we go. This is the one that everybody is so concerned about. Last Saturday, I had a lady in my office, and we spent really well over an hour and a half looking at the directives of physicians, and there were some things she actually wanted to add to it. So even though these are Texas forms, you can really make them your own. You can pull it apart here, or the lawyer can, and add some things. The directive to physicians is a legal document. It deals with end of life decision making. It deals with a condition that's irreversible or a terminal condition. And the form even has a page that defines what the law has come to understand is when something is irreversible or terminal. And there's been a great deal of controversy about what exactly is Alzheimer's. And I think some of the latest cases have said, well, it's irreversible and it's terminal. So some things are both. Now, the directives to physicians, it's really much more simple than we think because it deals with end of life decision making, but it's about what happens if my heart, when, not if, I guess it will stop, when my heart stops. And I remember a mother being taken to a hospital with a heart attack or at some point, and they came in the nursing home where she was, and they beat on her chest. And finally, when she got back, she said, I don't want this to happen to me again. And so there is an additional document that can be signed usually at a nursing facility or outside of a nursing facility, that with two doctors that will say when it is time, when either the person makes a decision or the agent makes a decision that they don't want any more, they want palliative or just supportive care to be kept comfortable. But we're still are talking about a heart stopping. Nobody really stops your heart. I guess it can stop if supportive procedures are removed, but no one takes um, an active role in stopping your heart. But mother said, if my heart stops, I don't want them to take me to the hospital. I don't want, and the doctors signed off on the do not resuscitate, out of hospital, do not resuscitate, which is a form signed if this condition takes place. And they put that in her file, put a little red um, paper clip or something on it. Doesn't mean that it would always be honored if someone doesn't know it's there. But I think mother's heart stopped, and she had two nurses with her, and they understood the document was there. The document was placed in the room where mother was, and they did not resuscitate her. They let her go because that's what she wanted, and that's really the definition of death. So anyway, yes, and thank you, Xanda. The directives to physicians, also known by many people as a living will. I guess I always forget to call it that because there's no such thing as a living will, but many people refer to it as that. So I've learned to just let it go and refer to it as a living will, um, because it has a lot of the ability to maybe make people think that it has a little bit of both designations, but it is actually a directive to physicians. And my last client spent quite a bit of time adding another paragraph. She wanted, from a time she is diagnosed with um, placed on life support or whatever, she wanted to be sure that the medical community waited 10 more days before they took her off. But she'd had some terrible things happen to a relative, so she was really frightened. So we put that in there, and also that they would that a what do you call it, a ethics committee would be placed. In every medical facility has the ability to put in place an ethics committee of doctors, of lawyers, of just ordinary folks. To What it does, it slows the process down and has a chance for the ethics committee to meet and really look at everything, so that the person trying to make the decisions, and maybe the patient too, though fairly rarely, where that person is able to be assured that and supported in a decision to perhaps to remove life support. And I was at one point the agent for a fellow attorney, a woman who was gravely ill, and I got a call from he was in the hospital, and they said, she's had a stroke. Can you remove life support? And I said, yes. And they said, will you? And I went, no. Uh, and I said, but I want an ethics committee appointed because I knew that would slow it all down. Well, they messed around with that. And finally, one day I called and I was just checking on Deborah. And they said, well, you want to talk to her? So guess what? This is one good reason. Why why you want to take have the ability to just slow it down, because you just never know. And the lady in my office who wanted to really redo and add her own paragraph to that directive to physicians about end of life decision making. She was wise to do that. I don't have very many people that do, but she'd had some unfortunate kinds of situations with a younger member of the family that she felt they removed that too soon. I've really never seen that, and maybe it didn't happen to her, but I wanted her to feel comfortable with the document. Okay. All right, Xanda, how about the next one? Are there any other end-of-life documents I should know about? Well, we've talked about the three key ones. I wanted you to see there is the medical power of attorney for routine decision making, the directive to physician, which is an end-of-life document for terminal and irreversible conditions, deals really with the stopping of the heart. And the document we talked about a while ago, the out of hospital do not resuscitate order, isn't really an advanced directive, but it supports these. It really is used. It's not signed in advance. It's signed situationally at the time it's really needed. It's not a direct advanced directive, but it supports those documents. And because at this point you want to know, is this the time? Is this the time that we are requesting is it time for aggressive treatment to cease and all care be to keep me comfortable? And it requires the signing of two doctors and is in your yeah, two doctors, I think. Thank you, Zenda, and two physicians will sign that. And with mother, gosh, after she talked to the nursing home personnel about the document, I could have in her place as her agent, but she was perfectly capable. I said, go talk to mother, and I think they kept her in there about kept her, she kept them in there about 2 hours on this, and it was sent over to her doctor, and about a month later it came back that they felt that it was time to put this in place. So these documents, Texas, I think, has some excellent documents so that things don't get out of hand. And I especially like the appointment of an ethics committee because it does slow everything down, and you get other people to look at this case and tell you whether they think this is time, we need to wait longer, and it's really great because is it time for palliative care to keep me comfortable, and when my heart passes, when my heart stops, then we don't do any we don't start my heart back again. It's, of course, that's my wish, and that was my mother's wish. All right, let's see. Number 14 there, Sandra. Ah, now here this is the one we really want to talk about here is my last will and testament. Let's see. I do have one, right? Maybe I don't have one. And where is it? I've done so many wills, I guess in the hundreds in the last 50 years or so. And the most of the question after someone passes is, Mom just passed and she had a will. Oh, really? Well, do you have it? Well, I don't know where it is. And we try to talk to people after they do a will and be sure they know where it is. And and it, many times they can't find it. And I just say, keep looking. And we'll talk about probate in just a minute. But reviewing your will, I think, is important as you're having an annual physical because family circumstances change over time, and certainly you should review your will. Maybe a beneficiary of your will or an executor passes away, or there's a significant change in your circumstance, or you might change your mind about your wishes. Now, when does my will take effect? It doesn't take effect during any of these times that I'm trying to change it. My will takes effect at my death. My property that is Rosemary's estate is the property that I own at death. So the property that I have when I make my will might certainly probably isn't exactly the property that I will have at death. But so wills are generally, let's say maybe if I have three children and I will one third to each one, I've had, you can disinherit I you can disinherit your nearest of kin. I have people often that are disinheriting a child. I'm not big on freestanding trusts, but I do them in a will. We have sometimes um, I had a case once that the two daughters and a brother, and the brother was an MD, but had been so severely mentally ill that he lost his license, and his mother was really worried that he would take money and just it would be gone in a month, and so we put his one third in a trust in a will. And I do them in a will for various reasons. Someone is under 18, someone is underage, or they have a disability, and I will do them in a will. I don't do them otherwise. I don't do freestanding trusts. A lot of lawyers don't do them, but I do have some firms. If you need a that kind of referral, I can make that for you. So anyway, so if you're reviewing your will, there can be a lot of changes. Maybe your executor has passed away. Uh, Hopefully you have an alternate or a change in circumstances, or you've changed your mind about your wishes. You can also make distributions to charities in your will. Certain things don't go through your will. Remember, if you have a life insurance policy, accounts that are retirement accounts, those any accounts that have specific beneficiaries, uh, and the beneficiaries are named and living, those accounts would go would be dispersed with the death certificate and would not go through your will unless you make it go through your will. So that's why it's a good idea to really just put all the information out there for your lawyer to look at. And anyway, and your will is not effective if it can't be found after your death. Occasionally, I think I have actually testified on one will that we couldn't be found. I had a copy of it. Well, I had a copy of it, and so we reviewed that, and I went into court and said, "Yes, this is my signed copy. We've not found the original, but I would be the person that he would go to make another will." And because this will went as it would have without a will, the court did admit my copy, but this is very rare. So we want to be sure you keep hunting, keep it in a safe place. Safety deposit box. Well, the law has changed about safety deposit boxes. Let's say that, an only child and I'm on mom's safety deposit box. Whoever's on it owns it at the end of death. So I could go in and then and maybe get the will out of the safety deposit box. Probably that might or might not be the best place for it. So anyway, the main thing is after death, you want to be sure that the original one is found. And so we have everybody sign in blue ink so that we know, because man, these copy machines are so great. All right, next one. And Xander, I don't even know. I don't have any way to know what time it is. So just tell me if I'm. All right. Can I just get one of those fill in the blank forms and get it notarized? And for a long time on one of the radio stations, they were advertising these. Well, a fill in the blank will, or fill in the blank, whatever it is not a will and it can't be probated. Why would that be? Well, okay, the court doesn't want you um, to be filling in the blanks. And the reasoning is that they don't know when each of these blanks are filled in. And so a fill in the blank will can't be probated. You'd be better off if you had no will at all and you felt really ill to grab a blank piece of paper. If I had that happen, I would say, "Oh, here, my Rosemary Redmond. Oh, here it is, whatever of May. I After my death, I make this my will. So after my death, my property, all of my estate or property, anything goes to, but the name, and then I name this person independent executor, and date it and I sign it. And in Texas, that's still a will. I don't recommend it, but it's better than passing without one. We call that a holographic or handwritten will. Texas still has it. Okay. And then probate is the process used to certify that the document is your last will and testament. And it is for of the transfer of property after your death to new ownership. And that's why you have a probate. You have 4 years from the date of death to probate a will. Sometimes wills are not probated. We also have a transfer on death deed that can be signed at the same time you do your will. That can actually cause the transfer of real estate upon your death. We've been doing a lot. We didn't do those for a long time. The court finally gave us permission with a form that's better, and so we do sometimes go ahead and transfer that. Sometimes that means you don't have to probate the will. We just don't know. But probate is the court process that certifies the documents, your last will and testament, and it transfers the ownership. And that's what you're trying to do. In other words, what mom did in her will is she had a nice house. I'm sitting here in it right now. I probated the will, and the ownership now is in my name because I put a certified copy of the will and order in the deeds records. Okay, I think next one. Can I disinherit my natural heirs? Yes, you can. And do you have to leave them $1? No, not in Texas, but and this is really hard. This is a really hard thing for people to do. And sometimes, because I sometimes put a trust in a will, sometimes rather than disinherit them, what they really want to do is have someone in the family as a trustee who can take care of the part of the estate of that person, so that it isn't that they don't receive anything, it's that someone else manages it for them. So, but yes, you can disinherit, and we disinherit them by name. I leave nothing to my child, Gertrude or whatever. Okay, next one. Is there a worksheet I can use to design my will? powers of attorney, medical purpose. Yes. In fact, you can get these really online. Just put will worksheet and it'll pull up all kinds of things. It'll probably pull up some lawyers too. So sometimes you get the worksheet printed off, and maybe you'll use that lawyer, maybe you won't. But yes, they're available. And you want to use Texas specific documents because other different states have different requirements. It is a requirement um, that our executors be independent, because if you just say executor, you might find your executor having to go back to court for everything that needs to be done, because being independent is you trust that person long enough, you trust that person enough that you know that your Texas specific document will be handled by that individual. You trust them enough to be independent. And so independent is always a word. First thing I look for when someone brings a will into probate is the page about the executor, be sure they're independent. All right. And we will provide resources for you to use in your state. Okay. There is a document called appointment. This didn't used to be a document. It's a Texas document now, called appointment of agent to control disposition of remains. And then you might say, well, I already made my arrangements. Well, but funeral homes want to know who has the right to sign to implement the instructions that you've made. Funeral homes are getting pretty cautious about who has the legal authority. I live in Ennis, Texas, and I think they had to uh, to try to deal with covering over some bullet holes at one point. People, this is a very terrible time for families, and if they haven't gotten along, they may bring it all to the nursing home. I mean, to the funeral home. So this is why I always offer this document, and most people do assign it. Who is in charge of making my arrangements so that they can deal? Funeral home can deal with one person, even if you've made your all of your arrangements. Still, somebody needs to put it in place. So designating a specific person with the authority to initiate the process, even if you've already made your arrangements, who puts it in effect. So we have that document, and that's pretty much a part of everybody's, every attorney's documents that they offer. Okay, what's next? Okay, what if I don't have a disposition of remains documents? Well, sometimes a funeral home will request a copy of your will, of the person's will, just a copy of it, and they will work with the person that you have listed appointed as your independent executor. I've had that happen when I actually faxed a will down to Harlingen. They were holding up the funeral of this lady, and I faxed the will. I had just happened to have the file with me, and I faxed the will down to Harlingen, and they saw that this person who had made her arrangements was going to be the independent executor, and the funeral took place. Man, I felt like I had really done something great that day. I just happened to have that will in my briefcase. So anyway, but the independent executor is not officially appointed until the will is admitted to probate. So there are a lot of things to be done, but it doesn't have to be overwhelming because an attorney will certainly take you through this. The main thing is to have the documents. Let's see, do we have a number 20 there? I'm not sure. Ah, there you go. It isn't as complicated as you think, and you probably, hopefully, the questions that I've answered, those questions are most often asked me. And heavens, are there attorneys that concentrate in elder law? Because a number of people that I've talked to, they have a relative who's passed away, and it's not in Texas; it's in another state. And so, in Texas, of course, you can contact your local bar association. They have lawyer referral organizations, and I have long been a member of the National Academy of Elder Law Attorneys, and it gives you the site there to find qualified elder lawyers in every state and city. This is a fantastic organization because what I find most often is I have so many people who pass away with a relative in Florida. I don't know. I guess it's just having property in Florida is such a wonderful thing, and maybe maybe the relative is there too. It's a nice retirement state apparently, and so you can find elder law attorneys. You can look and find all of their qualifications on the NALA site. And let's see, I think we have also many other. Um, we have some other referrals as well, right? Okay, we just did that one. Let's see what number. We have a number. We have the next ones that has some different referrals. Is that right?
Hold on a minute. That one didn't make on my copy. I think this is your copy, but we will be mailing everybody, emailing with the slides. We will email a PDF that includes an entire slides that has resources. And these resources are how to find in another state, how to find area agencies on aging, which, as Rosemary knows, area
Yeah.
agencies on aging keep a list of attorneys who are elder law attorneys. In some cases, like in Rosemary's case, she actually is affiliated with the Dallas Area Agency on Aging as an elder law attorney. So those will all come in your finalized copy of these slides with that, with all of those resources in it. Uh,
Right.
Looking at our comments and questions.
Oh, Xanda, I had one I just saw, and someone said there's only a couple of elder law attorneys in Wichita Falls. Okay,
Uh-huh.
then what you want to do is go to the county
Yes.
and search for elder law attorneys in the county. It might not be as convenient, but you might find someone very helpful.
And that would be, could be the same case, and that's in the resources of your state. And that was one comment I made, Rosemary, is that in some states, these documents are called proxies.
Hmm.
So you could do a search on your web browser using your state, and in sometimes, well, for the documents, your state, and then proxy or powers of attorney. And if you want, to find county resources, you just put that into your search window and it should bring that
Hmm.
up. What you will have in your resources is there is a link to it's Elder Care Locator. And again, you'll put in your zip code and it will take you to the area agencies on aging. And they're very helpful with getting that information out to you. You will notice on your screen now that there's a session survey. Please fill those out for us. But in the meantime, there are a couple of comments and questions.
Sure.
Um,
Well, and I want to be sure that people understand that we're talking about Texas residents with
right.
Texas documents. We ought to have one set of everything for the entire United States. We don't.
Mhm.
So
Well, we
these are
don't.
state by state. So, but you can find all of this information in any state, and that's why the NALA group is really good because you can go to the state, county by county. They'll find you people that you can get a lot of information just on the phone, so they can tell whether you might be a potential client. So we can't stress enough that that's a great organization to. And if anyone has questions they want to ask me, Xanda can give you identifying
Right.
information. You can call me up, whatever. I love to talk to folks on the phone. So,
I have a question here. What is the logistics process for your executor to process your will after you die? What do
well,
you do?
that's what probate is, and you cannot do it without an attorney, but you certainly would be glad to have an attorney because they would take you through the entire process. And it's a costly procedure, but that is borne by the estate of the person who has passed away, and you should not become personally liable for those expenses. But and again, that's if you're in Dallas or Tarrant County, Dallas has a Dallas Bar Association. Tarrant County has I think it's Tarrant County Bar Association, and you can get a lot of information. They have lawyer referral services. So if you're in Dallas or Tarrant County, and many of you probably are, you can get information from them. Yeah.
Also, in some of the larger churches have actual members of the church that may have that expertise that will donate their
Right.
time. I've heard of
Hmm.
that also.
Yes.
So don't, just because someone doesn't have money is not a reason to put these off. And again, going to the area agencies on aging, they may be able to point you in the right direction. On the list that you'll get, there's Northwest Texas Legal Aid, and that serves, uh, they provide attorneys at a
Mhm.
prorated or no cost basis.
Yeah.
Rosemary, can you request an ethics committee review if there is a controversy within the family?
Are you saying can
That's a
I?
question. That's a question for
Oh,
you.
yes, I've had attorneys that told me that they have requested them on behalf of a family member.
Mhm,
So it doesn't have to necessarily be the person who's appointed the healthcare agent. Any family member or anyone of interest. I had a family where the woman was in that situation. She was not married to this gentleman who was present, and he wasn't in her will, but he had status because they had a relationship, and so he requested it, and it was done. So they're more likely to appoint the ethics committee than not.
okay. Uh, Someone has stated, I'm 45 years old and I did all of these documents and emailed a copy to everyone in my small circle, including my bank. And I had asked the question and you had answered it. How often you review the will? Sometimes, as in the case of spouses, the health conditions, maybe you've appointed them as your
Yeah.
as your agent, your designated person, and because of their health has changed, uh,
Yes.
or you've even lost that person, the importance of reviewing that. Otherwise, you're not going to be very far ahead if that
Right.
person is not available to even make those decisions.
Well, that's true, and that I've had a number of spouses have called me and said my wife is declining, and I
Mhm,
know that I know that she had always wanted to change her will, and while she can voice that, we need to get in there and do this. And so any change of circumstances will,
mhm,
but let's say Texas has long had to deal with the problem that the family could be in the middle of a divorce,
mhm,
and one spouse pass away. You'd be surprised how often this happens. And Texas law says that if you're in the middle of a divorce, uh, and you actually have been divorced, I think you have to have been divorced. There have been some wonderful cases on that. Wow, if you have been divorced, the assumption is you would not want a will to that person, and so even if that person is in your will, they cannot take under the will if you have divorced a spouse. Now, I had one case, I didn't have it, but I read about it. They were like 2 days, 2 days they would have had the hearing and finalized the divorce, and he died, and she inherited because it wasn't finalized. So, but
mm,
the presumption is if you're divorced, then that person named as wife would not take, but the alternate beneficiaries would. That's why you always put alternates in these things so you cover everything. I've been accused of handling everything but nuclear war, so but that's
mhm.
good because you never know, right?
Right. It's about 2 minutes after the hour. We realize that some people may have to leave us, but we do have three more comments or questions.
Okay.
Rosemary, this is would be state of Texas only. What do you know about the Ladybird deeds? It might be important to me in the future as I'm the only child and caregiver to my elderly and disabled parent.
Sure, we don't call it ladybird deed anymore because the Texas Supreme Court didn't like the wording. It's called transfer on death deed, and we do these. Usually, we do a. People would say, "Well, I don't need a will if I have that." Well, yes, you do, but along with the will, we do these, and it lets. It's a very odd thing, but this is a wonderful document, especially in your case. We would do it, get the legal description of the property and the person who owns the property, like mom, maybe would do as an actual deed and it becomes effective at her death. And then that document's already been filed in the deed records and it transfers property at death. It's a great document, really is. Do you still
Okay.
need a will? Yes.
Okay. Someone has said, I was told I need another POA when the license of the notary expires. Is this
Oh, no, no,
right?
no. That's not true. I've never had anyone ask that question. That's a great question. Thank you. No,
Okay.
no, no. It's the date of the no if the notary seal is valid on that date, that's it. No, you don't need a new document. If it's already valid, it's still valid. Right. Good question.
Okay. And May Bryant has asked, what is your phone number, Rosemary?
Oh, okay. I only have one phone number, 214-502-3395. 214-502-3395. The only number I have. I'm finally down to one. Thank goodness.
And I would just request that anyone who calls Rosemary, that you limit to, her job is not, unless you retain her as your attorney, be careful and not be asking a lot of specific issues to your situation. Just respect her time about this. But if money is an issue, those resources that I referred to, and I know
Yes.
Rosemary would go above and beyond trying to help you find what you need. I
Well,
have
I hope
another,
that there's still, that we've been taking cases through the Dallas Area Agency on Aging, and I know you have too.
mhm,
And yeah, we hope to be able to continue to do that.
right.
That's been those programs that we've been involved in, Xanda, have just been and continue to be wonderful
They
programs.
are, they are. It's incredible. Here's another question. Does anyone know anything about Medicaid expansion in Texas to include adult children who are caregivers to their parents who are on Medicare and not themselves eligible for Medicaid? Does that make sense?
I don't, I've long ago given up knowing anything about that, but I'll tell you something. If you're in Dallas and in Ellis County counties, there is a law firm called the Hale, Hale, Hale Law Firm, and they have some paralegals that give out some wonderful advice, and it won't cost you anything if you just ask for a paralegal at the Hale Law Firm, and ask those questions because they are in the business of dealing with Medicaid eligibility, and everything is sort of up in the air right now. And I would suspect they would be the people to help you. But I've sent a lot of referrals to the Hale, Hale, Hale Law Firm.
Um,
You can
also,
Google it and find the number.
Also, the Ladybird deed, it's now called the transfer on death deed, correct?
Yes, Lady Bird deed
Okay, that
is
you
now
referred
the
to
The
earlier.
state Supreme Court didn't like the other one, but they do like this one, so we're doing it. If it is a transfer on death deed.
Mhm. Going back to Medicaid expansion, anything has to do with Medicare, that is another really good question for Dallas, or for the area agencies on aging.
Right, they have benefits counselors.
Right, by law, every AAA has to have benefits counselors. They're specially trained in all things entitlements, Medicare, Medicaid, Social Security, and they are really good first stop, and they may be able to answer your questions.
That would
We
be the best first stop.
Yeah, we have been advised that as of right now, all money, none of the Administration on Aging or the Health and Human Services money for caregivers or for older adults is in jeopardy of being cut. That they are still authorized and allocated at least through September. Another question, can you, and again, folks, if you need to sign off, we understand. Remember, this is being recorded. It will be on the Caregiver Teleconnection website within a couple of days. It'll also be on our website, which is www.familycaregiversonline.net. Family caregivers, plural, online, all one word, .net. Here's a question. Can you address avoiding use of a lawyer to probate a will by having real estate in monument of title?
Immuniment of title is a
Mhm.
probate,
Okay,
and the filing fees are the same. Immuniment of title is a probate.
okay,
It's a less expensive probate because you don't have to do an inventory and you don't have to notify creditors. It's where there are no creditors. So the fee for that is actually much less than the full probate, but the bill, all it means all the debts have been paid except for those on real estate. So it is a probate. Yeah, that's what a muniment of title is. It means muniment, or it's just to change the title, saying there's no debts, there's not anything to do, we can do it less expensively.
okay. One new message, and I will be listing, I will be listing Rosemary's phone number. Um, what is the name of the staff at AAA to help with Medicaid questions? Again, it's benefits counselors. Benefits counselors. And if you will,
The regular area agency number, yeah.
if you look up on any area agency on aging, and again, that elder care locator has a very quick and easy way to find the area agency on aging that serves your community. This, our caregiver teleconnection is actually going to 16 counties in north central Texas, and it goes all over Texas. But that resource, elder care locator, that is a good way to start. You also can use 211, which is a phone number across the United States. Sometimes you have to leave messages there. So if you can get to a AAA, that might be easier. Although frankly, the issues are right now that um, um, don't be surprised if you have to leave phone numbers at a lot of these resources because there's just a large need right now. So Rosemary 214-502, correct?
Right.
3395, and I'm putting that in the chat.
Okay, great. Yeah, I'll be happy to. If I've confused you in any way, call up. We'll straighten it all out. So, or even if I haven't confused you. So, but thank you so much. I always enjoy this, and thank you, Xanda, for asking me to.
Thank you, Rosemary. It's always, you always have great delivery with this, and your story itself is just so fascinating. All the different aspects of what all, going back and getting your master's degree and your specialization. And I don't think I've ever actually heard the story of that you are uh, a Catholic on loan to the Christian church. I've
I
never
know
heard
the
that,
School
you say
Sisters of
that
Notre
before.
Dame
That's
said,
terrific.
that I'm on loan. So
Yeah, you're on
that's
loan.
nice.
That's terrific. Thank you, everyone. I hope that you have, I know you've benefited from this presentation. And remember, you can review it with the slides will be also connected with the website where the recording will be. So
Right.
thank you very much. Again, thank you, Rosemary. Everyone, take care of yourselves, and we will be talking to you next week. Next month, not next
Next
week.
month, okay.
It'll feel like next week, next month. Bye, everyone. Thank you.
Thank you, Xanda. Bye bye now.
Bye.